All right, welcome everybody. You're watching the Fox News post-game analysis of the week in legal tech here. This is Bob Ambrogi, and today is July 10th, 2026. This is the show where we talk about the top stories in legal tech and innovation from the past week. And let's see who we have on the panel today. We have returning from a long, long absence from the show is Rhys Dipshan. Rhys, say hello.
Hey, I'm Rhys. I'm the editor-in-chief of Legal Tech News, and I have the best camera out of everybody here on the panel. Hope everybody can see me. Okay.
Yeah, we can see you. All right. And Nikki Black.
Hi, my name is Niki Black. I am the Principal Legal Insight Strategist at 8 a.m., the team behind Law Pay My Case, Case Appear, and DocuWise. I write legal tech columns for ABA Journal Above the Law and the Daily Record, and I'm happy to be here. I don't know. I never have anything to say that's interesting after.
And you have a new Substack, right? Do you see that?
Well, only because last time, so Kristen in the audience said you should cross-post your stuff to Substack. I'm like, so I said, well, if you say so, so I'm doing it.
Okay.
I do what everyone in the audience tells me to do, all the attendees.
There used to be a weird app like that. Anyway.
I'll put it
Okay, Victor.
Hi, everyone. My name is Victor Lee. I am Assistant Managing Editor for the ABA Journal. I had a 20-minute talk with Big Mitch McConnell this week. It was great. He gave me some stock tips and some World Cup insight. It was wonderful. Changed my life.
Victor, you also got some recognition this week. Do you want to mention that?
Oh, yeah. Thanks. Yeah, my book, Supreme Pressure, The Rejection of John J. Parker and Birth of the Modern Supreme Court Confirmation Process, was named finalist for the Kirkus Indie Awards. So I guess they'll announce the winner in late August, but just being nominated for finalists is pretty cool. So I was pretty excited about that.
That is pretty
That's
cool.
cool.
Congratulations.
Congratulations, yeah.
Thanks.
And Joe.
Joe Patrice from Above the Law and Thinking Like a Lawyer. I'm here. I did not talk to Mitch McConnell this week, so I really don't have any fun thing to say.
All right. And last but not least, Steve.
Hey, Steve Embry. I write the blog Tech Law Crossroads and for Above the Law. And I actually went to see Mitch this past week, and that he didn't really have a whole lot to say, to be quite honest. He was pretty quiet.
All right. Yeah. All right. I'm gonna start with one of my own stories this week, just because just this morning I wrote about. I think Joe is in the process of writing about, or hasn't quite, or has written but hasn't posted, or maybe you have posted, or where are you on that? Anyway, the yet another law school AI policy. We've talked about these before, and I was fascinated by the when I wrote about it this morning to the reaction on LinkedIn, because there's been a lot of reaction to it. This time it's the University of Chicago. Well, I think last time we talked about it was Berkeley. Maybe there's another one after that, but Berkeley Law School adopted this basically no AI for law students policy, which seemed a bit overboard at the time, and perhaps counterproductive in terms of teaching law students the skills they need when they actually go into the real world. But now University of Chicago released a policy yesterday, something it's calling Rethinking Legal Education in the AI Era. And the headline of it is that they have banned the use of electronic devices in all 1L classes. And I think that's kind of what's getting the most, getting people roiled up the most, for and against, from what I'm seeing on LinkedIn. But that seems a little extreme to me, but some other parts of the policy I think are actually seem kind of reasonable. I mean, other parts of the policy, sort of once you get past 1L, there seems to be this idea of trying to allow both faculty and students some discretion and leeway in terms of how they're going to use AI, how they're going to incorporate AI into the curricula. They have this thing where it didn't happen when I was in law school, but maybe this is something more common in law school now. where they have this upper level writing requirement. And what do they call it? Their SRP, their substantial research paper requirement. And they're not like, for example, with regard to that, they're not saying students can't use this in writing their research paper. They don't seem to expressly say that. But what they are now doing is adding in kind of an oral requirement, so the students need to come in and discuss and defend and go talk through their research paper, which seems to be a great sort of a smart way to see whether students are really learning something here or just applying AI to something. And the kind of the main focus of their AI training will be both in their legal research class, which makes sense, and in their clinical education, which I think also makes sense. So I don't know if any of you guys had a chance to look at Joe. I know you had a chance to look at it. I don't know if anybody else did, but curious on what people think about how Chicago is tackling this issue.
Yeah, Chicago's crazy.
I took a look at. Yeah. No, that was perfect.
Got a reaction.
No notes.
Like even when I was in law school, people were like, "Man, Chicago is nuts." Like people are known there for like because this is before the day of like easily accessible like practice tests on the internet. So people would they had books in the library. People would rip out the practice exams so other people couldn't look at them. People would like so Chicago was cutthroat even by law school standards. That's just an aside though. So yeah.
Yeah, the policy itself. So there are elements of it that I do think are interesting and valid. I do think that there is good reason to try to create some sort of limitations on AI as far as 1L education, because you're trying to teach. We had that. It's not legal, but I don't know if anybody saw it going viral. The professor who surprised the class by saying suddenly the final was going to be in person as opposed to at home, and everyone, all except like 3 students, scores just wildly tanked on the final as opposed to the midterm. So there's reason to take some sort of action. I think that and I also think that the part of the course, they don't want them in the doctrinal courses. They don't want you to have AI around or computers. We'll get to that. But the legal writing part, they do want AI involved. They do recognize that when folks have to go down to be to their big law summer associateships, they are going to not be impressed that you know the Erie doctorate off the top of your head and are really going to want you to know how to use AI to do some research. So I thought that was a good and nuanced take, especially after Berkeley's kind of blanket take out of it. That said, the getting rid of all laptops is just absolutely insane to me. It is insane because on a lot of levels, not the least of which, I don't understand what that does for the AI front. It's like if you're leaning into the Socratic method, like I don't know if these people who wrote this policy have ever used AI, but it's not like when the professor says, "You, Mr. Patrice," you go, "Hold on." Well, that Claude is thinking. Like that's just not how it operates. And when it's done correctly, it's not even one answer. Whatever answer you give, they find some flaw with, and then you get grilled on that for a few minutes. Like there's no way that you can use AI in the classroom in that way. And so to that extent, I don't understand what the purpose of this is. It almost felt like I thought it was like some group of Luddites decided that they were going to use this AI thing to get what they've always wanted, which is rid of all of the clickety-clack in the classroom, which I will admit probably would annoy the hell out of me as a professor too. But that's neither here nor there. At the end, and I actually think I put this in my piece. I was a handwritten note person my whole life. I believe the science that says that handwritten notes make you retain things better and smarter. But my experience with at least the undergrad cohort that I teach, they're incapable of taking notes by hand. Like it doesn't even clock with them what they're supposed to write down. Most of them have grown up in a world where they just look at PowerPoints. They aren't used to the idea of hearing someone talk and say, that's something that I should be writing down. They're used to looking and seeing, oh, there were 3 bullet points. I'll get that later. So taking computers out of the classroom is not going to transform them into magic note takers all of a sudden. And I think it's a little ridiculous to think it will.
You've
You know,
forgotten
the thing that
Josh Broder's lawyer AI in the courtroom thing, which was supposed to be like the judge asks a question and you turn and type the question into your AI and wait and say, Your Honor, the answer is.
Yeah.
You know, the thing that strikes me about this, I was thinking about it and listened to a podcast today that made me think this. It's all sort of based on this assumption that students coming out of law school that use AI are going to be worse lawyers than students coming out of law school that don't use AI. And, you know, on the face of it, that sounds like, yeah, that's got to be true. But the lack of empirical data for that and controlled studies is striking when you really think about it. I mean, it sounds good, but Tom Martin did a podcast, and there was a Minnesota professor that did a controlled random sort of test, and he took law students who were unfamiliar with a section of the law. One group had to use AI to become familiar. One group had to become familiar on their own. The second part of the test is with both groups, they had to apply the law to a set of facts and a set of issues. And, you know, of course, the assumption would be those that used AI to learn the law in question would do worse. In fact, they did better, which is kind of, you know, it sort of says, but maybe we should, like, before we start banning laptops out of the classroom, maybe we should sort of think about what evidence there is, what data there is, and are we really doing anybody a favor by jumping to conclusions or that are based on just what a bunch of old white men think?
Yeah, but in fairness to Chicago, their policy recognizes they consider AI an essential skill and an important skill. They're just kind of delaying up past the first year the implementation of the methods for learning it.
And that's exactly right. But they're basically saying you cannot. The first 1Ls cannot use AI in the course of their studies. And I would say, well, that may be true because that may make them worse second-year students. But it may not be true. I mean, we don't know the answer. Yeah. We're just sort of saying, oh, it sounds.
But they're not even saying that. They're saying you can't use it in the classroom. Is really all they're saying. Yeah. They're not saying you can't use it outside the classroom.
So
right, which is the distinction from Berkeley, who was saying you can't use it for anything ever.
So if you had asked me this before I went on my sabbatical, I would have had a very different opinion. Something about the sabbatical and checking out and not really being on AI for work purposes. I still use it almost like a search engine while I was out. Changed my perspective on AI, on what it's doing to our society, on what it's doing to our brains, on how it's impacting the content that we consume. I think that there is a significant, a trend isn't quite the word, but there's something happening that is significantly, it's like a brain drain. It's reducing our ability to think analytically, to write analytically. People are outsourcing decisions and choices and options. And I include myself in this. Like I do find myself, and I've been stopping myself lately. Like I have this simple choice to make in my personal life. I'm going to see what AI thinks. I'm like, no, I'm not going to ask AI. I'm a grown ass adult. I've raised 2 children to, adulthood. They're doing great. I can make this decision, using my own devices. And what I'm noticing happening, and I think that what they're doing is correct. For year 1, I don't think you should have devices in the classroom because you need to actually be listening and taking notes and processing that information. You need to learn how to do that. Because if you have AI that is there transcribing what's happening, you don't have to listen, analyze, process information, which is what you have to do as a litigator, which is what you have to do in the courtroom, which is what you have to do when you speak to clients and they come into the office, which is what you have to do when you go to senior attorneys and listen to the assignment and tell them the results that you've come up with. We're no longer processing information. And I'm on social media a lot more than I used to be because of the winery. And I'm getting all this AI, anti-AI, people talking about how this is happening, using AI drafted scripts. It's killing me. They're criticizing AI and you can tell they're using scripts from AI. And I'm seeing it everywhere. once you start to know the patterns, it's in the news, it's in all the newspaper articles, it's in all the blog posts, it's all over LinkedIn, it's in all the content scripts, it's in people's speeches. It's driving me nuts. No one's having original thoughts anymore. And I think that this is a problem. And I think that the way that they've approached it is actually smart. I don't like the idea of what Berkeley did, where it just bans it outright. I think that actually Chicago has approached it in a very methodical, appropriate way that ensures that for the first year, these law students are thinking critically. It's not just Socratic method. It's listening into information, processing it, taking the notes, reviewing those notes later, and maybe having AI analyze those notes and create an outline from it. Just taking a picture of it but I think that they're actually on the right track on this one. And I can't believe I'm saying this because I would not have said this a month and a half, 2 months ago.
But
Although,
I
I
think it goes too
makes a good
far.
point.
Sorry.
No,
Joe makes a good point. A lot of these students, they've been probably almost all of their lives, all of their scholastic lives have been using laptops to take notes and to, then saying, oh, you can't take notes with your laptop. That's a pretty hard shift.
Yeah.
I
Yeah,
think.
and
I mean, you can argue which one is better than the other, and that's certainly an argument. But to make that kind of shift, just boom,
Well,
And by the way,
and
I think it goes too far because and one thing that Joe said kind of didn't trigger anything into me until he said it. Just like I would doubt that people nowadays in this era can even take notes with their hands anymore. Like can even write things down. I can't anymore. And I grew up with no laptop, doing the writing and whatnot. But now it's like if you ask me to go somewhere and take notes with my own hand, I couldn't do it because it's just like the muscle memory is not there anymore. My handwriting has always been dog crap, and like now it's even worse. So I mean, I can imagine people like because I mean, look, if I couldn't have used my laptop during law school to take notes, I wouldn't have been able to get through. Get through.
I mean,
I think it sweeps too far. And look, like what are they so afraid of that is going to happen? Is like some professor's going to go and like do the Socratic method with someone, and someone's going to be typing the answers while the guy is like grilling him. So yeah, like so if the professor comes and grills me Socratically, and I'm typing away on the computer like trying to get the answers. That's not going to fly. You're not going to be able to do that in class.
But that you get grilled Socratically 2 or 3 times a semester. But you are supposed to be taking in information and analyzing it and thinking critically about it every single time you're in class. And listen, I agree. I can barely write at this point either. But when I was in law school, I learned to write in all caps because back then the exams were graded anonymously, but you had to write them out. And so I didn't want them to know I was a woman. So I changed how I wrote for law school exams. And you've got that flexible, you're able to do that at that age. You still have all these like connections that aren't quite made and you can be a little more adaptable. I think it's good for them to learn how to write. I mean, honestly, it's a lost art form and we all should know how to write at least. And I can't even do it. Like it's chicken scratch. I couldn't read what I said. I was like you before. I couldn't read what I wrote beforehand. Now I totally can't read it, but I think that it's good for them to do that for 1 year. And I understand the arguments, comments, Kristen's, not arguments, but the points Kristen's making about people that have all sorts of different disabilities and how it shines a spotlight on them. And I agree with that as well. And I know that there's no, I don't know what the middle ground is on that. I haven't thought that through, but that's also a really valid point.
Well, I actually feel it actually, helps people to pay closer attention to, it's a huge change to take away the devices. However, like when we were in school and you took our devices away, we would do okay. And you kind of have to force the change to actually have people pay attention. I mean, I'm sure there are people who go there and just sit on their laptops and record the entire class to transcribe, and they spend the entire time just going on the internet or doing stuff they shouldn't be doing too. And it changes how people interact. And you're trying to force a new generation to pay closer attention and to like analyze stuff and to actually be present. And it's a good skill to like have throughout your entire life. And I feel like we're kind of like overhyping how giant of a change it is. I mean, like, yeah, we cannot write for shit, although we can still write and we would still be okay at it. Like it isn't, like they're trying to throw them in the deep end. They're just, like trying to force them to be here in the class and actually pay attention. And people don't at all, like if they like have devices too, like they will just record everything and transcribe stuff. Like that's, like a common trend, and it just takes us away from like the actual classroom experience too. Like if we're trying to just, like transcribe everything and just record everything too, then why are we going to in-person classes in the first place?
I was listening and I was sort of wondering, when calculators came along, I wonder if the accounting professors had some, and people in accounting had similar debates. I sort of bet they did,
Of
actually.
course they did, yeah.
We heard it all the time. Like, someday you're going to be somewhere without a calculator. Will you be able to do this?
Right.
It's like, no, I will not, actually.
Yes, I'll
As it
have my
turns
phone
out,
with
I
me.
will
I
not.
can do it on there.
There's never a place that we don't have a calculator on our phone or something.
Well, when I was a kid, someone in class had like this calculator watch. Remember those?
Yeah.
You could type in things on your and like and everyone's like, oh, he's gonna cheat during exams. He's gonna get straight A's and blah blah blah.
Yeah,
I still
I'm old enough to remember when you used to have to use
advocate,
the
so I don't
slide
know what everybody
rule.
else is talking about.
You couldn't bring a calculator. You had to bring a slide rule.
Yeah, I do think that the sort of handicap accommodation issue is an interesting one. Somebody had also made that point on the LinkedIn thread that I was looking at on my post on LinkedIn. But the idea that if everybody has laptops, then there's nothing conspicuous about you having to use a laptop for accommodation purposes. But if nobody has laptops and suddenly you now have to go to the professor and say, I have this need for a laptop, and you're going to be sitting there in class, with this big bold laptop in front of you, it seems really really unfair and right in itself.
Just turn off the Wi-Fi. I guess that some people could have local models, but I mean, right? Like, but like most of that you could deal with there's so many other ways to deal with this other than get rid of the laptops. And yeah, like I said about the nature of note taking, it wouldn't surprise me, and this is just something Steve said, it wouldn't surprise me if this crop of students hears a lecture from a professor who is not of the PowerPoint let everything out generation. And the only way they can figure out what's going on is to take the reading and be like, give me a briefing that's a series of PowerPoints. Like that could be how they need to learn, unless we retool their brains for several years of atrophy on that front. But yeah.
I'm reminded of I've been to a couple of Bob Dylan concerts recently, and when you walk in, you have to deposit your phone in a bag that they then keep, which sounds okay. I get the point. Except when I was wearing an Apple Watch, and when I went in, I sent a couple of text messages on my Apple Watch. I'll probably be banned from Bob Dylan concerts from now on.
Yeah. I mean, I think it kind of comes down to that. I mean, I think that people, it seems like, there's good parts of the policy, but the device ban just seems to make no sense. It's not even rationally related. In my mind, it's just not even rationally related to AI. It's like as Joe and Victor have made the point that you're not going to be calling up Claude in the middle of a Socratic dialogue with the professor. It's really just having those devices is a convenience, and it seems like what law schools are trying to do with these policies to some extent is just sidestep coming up with more creative ways to teach law to students in ways where they can actually evaluate and probe a student's knowledge of the law without having to, you know, somehow ban their use of technology. I thought, I mean, that's sort of what the whole defending the paper orally kind of gets to, I think. It's like, sure, go ahead, create your paper using AI. I don't care, but you got to come in and tell me you understand what this is about and what the issues are and all of that.
It's how PhDs work.
Yeah.
I think you're right, Bob. I mean, recalling my law school, some of the professors were really good at using the Socratic method because they worked at it. And then some of them, they would just go through an outline and be like asking questions in a deposition that are irrelevant just because they're on their outline. So, I think you're right. If there was more time and attention devoted to those kinds of activities and how to use that method correctly and effectively, we might come out a little better.
Yeah. All right. Well, from the death of devices in law school to the death of Daubert from Agentic AI. So.
Oh yeah. So that's an interesting one. I was going to say something about PowerPoint in the chats, but I will retool here. So this was an interesting thing coming out of Extero. They announced that they have their new tool that isn't really a new tool. They've been using it in other contexts for a while, but now they're bringing it to digital forensics, and it kind of comes along with how the FBI has been using it. So, I mean, if it's good enough for Kash Patel. Anyway, but that aside, they now are utilizing it in digital forensics, and it is intended, you can see the benefit concept, right? It will allow investigators to take multiple different digital format stuff, seized phones here, social media posts here, take all of these different electronic pieces of data and pool them together in a way that the investigator can query. And it is designed in this agentic, since that's the buzzword we all use, to be able to take the goal that the investigator is after and create the steps necessary to get there. Now, Extero obviously, like anyone in legal producing this sort of a product, is very upfront that it's defensible, that it has an audit trail, and yada yada yada. Which agreed. What I thought about when I thought about the Daubert aspect of it is I do think that it probably is okay, and I think that a human expert is inevitably going to have to, no matter how quickly they can reach early conclusions using this technology, they have to be able to go to court and attest to the decisions that it made and all. And so that's fine. But I think courts are going to have a long, bumpy ride in coming to grips with the idea that decisions being made by an agent meet the standard of being peer-reviewed and well-tested and all the things we expect forensics experts to be able to attest to. And the expert coming in at the back end and saying, yeah, it made all these decisions, but I reviewed all those decisions and they're right, I think is probably a viable standard. But that's not going to be what a lot of these courts are going to think first time they hear it. And that was it. That was my story.
Yeah, I actually thought it was really interesting. Go ahead. Well, okay. I actually thought it was interesting in part because I went off on like a mental tangent. I almost had to turn to Claude to help me with this because on what the actual implications are for Daubert of all this. Because I was thinking about like, what is Daubert? I mean, Daubert is about using some kind of scientific or some other kind of a academic method or something to, I think of it almost more to like create evidence, whereas the forensic process they're talking about is almost more to find evidence. And so I'm trying to figure out if it was actually a Daubert issue. It was like with Daubert, it's like, okay, I'm going to use this test. I'm going to use a lie detector to create proof that this person was lying, and so you got to subject the lie detector to all this, analysis of whether that's a reliable method and all that. But with the forensic tools, agentic tools, they're really kind of going out and finding evidence. They're finding I don't know, evidence of an intrusion on a system or a document or an email or something like that. And then you're taking those pieces of evidence that they find and submitting them um, ultimately, I guess. So I don't know.
Yeah.
I went off on this mental
Well,
tangent as to whether this was even a Daubert thing.
so that's a good point. And frankly, I didn't think it was at first either, kind of along the same lines, because I thought, oh, it's querying evidence. But the more I started reading, the more it also struck me that that's technology that's existed for a long time. Like we can go query the evidence is not a new announcement. The new announcement is the way it is making these kind of connections to build out theories, sort of. It is the way in which they're now utilizing it, not just, hey, did somebody say this, but rather, you know, I'm looking for this kind of a connection, and it's going through and being like, well, there's this and this, and so my theory is that if this happened and this happened, then this connection, and so it is making logical leaps that you would assume that you would historically want a human expert to be saying, my my scientific expertise is the reason why I'm able to say the fact they did this means that. Because just being able to search it doesn't really require an agent, I wouldn't think. Like that's how
Right,
we've
right, right.
that's how we've queried documents for years at this point.
Yeah,
And that's what was a little confusing about it, because the
yeah,
more I read of got digging into all of their past press releases too, because I didn't want to trust the like the initial one. I want to be like, what? How does this differ or whatever? I started being like, oh no, this is more extreme, it seems, than what the just querying things would be.
yeah,
Anyway,
yeah.
that was my takeaway. But yeah, no, it's interesting.
Quick question just to throw out, like, will we have a situation where courts will need experts to kind of untie how the agent came to the
Oh yeah, yeah.
decisions it chose, and like, can we even do that too? I mean, like, like why a program tends to choose what it actually chooses is, can be very complex, and sometimes people just don't have the answers.
Yeah.
So like, how will somebody be able to kind of unpack or untie all of that? Like, and how is it totally defensible if we are completely unable to?
And I mean, there is this audit record that the human can look at and be like, oh, no, they made this decision. And theoretically, they would say, the AI decided to tie these things together based on some well-known theory of why you should be able to tie these two pieces of electronic whatever together. And so I am vouching for that, yada, yada, which I think is ultimately how it will play out. But I just think back to the early days of e-discovery and all, and like the judges who were like, wait, why can you do that? Oh, why is it okay for you to do that? And I just think that's where this is going to be, because I think Rhys is that's exactly what theoretically would happen. And can you do that? There is an audit trail, but then you enter the new psychological question of, even if you look at the audit trail, if you look at a fait accompli, are you saying, oh, well, it made these decisions. I'm looking for it to be unreasonable rather than actually making an affirmative decision of this being the most reasonable way to do it. What does that mean? Does that change the way you think about it? Like those are kind of like the deeper philosophical questions about AI that still keep me up at night. They
Yeah,
don't really,
yeah.
but that's the phrase I'm going to use. I have no trouble sleeping, so.
All right.
We're
Well,
actually going to just have like a few jobs, and the jobs are going to be people, trying to confirm and check the AI agents that like operate everywhere.
Yeah.
It's
Well,
going to
and
be interesting.
I like we had the philosophical discussion a couple weeks ago about writing and how I kind of view it. I view my own writing as like a dealing with a junior associate, and to some extent, the forensics expert had juniors who were making decisions that they had to vouch for on the back end anyway. So how is that how is that different than the agent making the decisions that you then have a legal responsibility to vouch for? How is that different than they gave it to you and you accepted it rather than questioned? Like, I don't know. It's
Well,
interesting, but I think it's going to
because
cause some curveballs.
when you it's the analogy I always use is when I was a young associate coming out of the PD's office into this law firm, I didn't know civil litigation. I'd never handled those cases. So the first few memos that they had me write and research, well, memos, they reviewed carefully. Does she know what she's talking about? Is she making leaps in logic? Is she misquoting cases? Like, does she know what she's doing? And over time, they were like, okay, yeah, she knows what she's doing. And I feel like that must be what happens with the junior forensic folks. And I feel
Yeah.
like that is not happening yet with AI. I mean, AI doesn't know what it's talking about. I mean, it's pretty clear that it's just it's regurgitating past information. That's why it's so bad at creativity and forward looking. But it also just hallucinates all the time. And I think that at this point, that's kind of unacceptable. That's a separate issue. I think a little bit.
No, I think it's sort of a related issue, Niki, because what you're describing is how the profession worked. I mean, you came in as a young lawyer, you learned, your work was reviewed, you gradually became more and more trusted. So by the time you were a senior associate, if I were supervising partner, I would say, oh, that's Niki's memo. I'm sure that's right. I mean, she's on the button all the time. But now it's the kind of thing was like, well, what if that senior associate was really tired and kind of just went and used AI and, you know, found a couple of hallucinated cases. Now I've got to go check everybody's work all the time. It's a kind of a conundrum, I think. I mean, it's almost to the point where you'd have to say, talking about not using AI in the classroom, when you write me my memo, don't use AI because I don't have time to go check and read all your cases.
From now on, everybody in the law firm's using yellow pads and no more computers.
How about the quill, the ink and the quill? I think that would be
Well, you
better.
were just saying, Steve.
That's the joke I made.
But if you get to the point where the junior associate using AI means that it's more work for the senior attorney, does it mean that by the junior associates using AI, they're just accelerating their layoffs? You know what I mean? Like, well, we'll just have AI write it. Because if the junior attorney is going to use AI to write it, I'll just have AI write it. What do we need them there for?
Right.
So
I got to do the same amount of work anyway. So
right. I
No,
don't know where we're headed.
that's
Right
a really interesting question you raised, actually.
I don't know where we're headed. I feel like every single day that goes by, we're like closer and closer to sort of just insanity. Like
Yeah.
it's happening really quickly.
The reason I said it was an interesting question is it was precisely the issue that the article that I put on the thing this week gets into. So
there's a segue for Bob.
no, we have to let Bob do the segue. He's gonna go someplace else. I can feel it.
I'm just mesmerized by the wind chimes in the background. I'm just kind of listening to. I feel like Niki must have climbed up a mountain in Tibet while she was on sabbatical and rejected devices and gotten wind chimes, and it's like it's all copacetic.
For the 8th time, that's what happened. There was no Tibetan temple or mountain. It was just COVID.
All right, Steve, I'll see your invitation to transition to you. And
all right. Well, the article was in the Futurism, and it was basically talking about the threat that we face when these AI providers move from a subscription-based service to a usage-based service. And so the point it was making is that it's inevitable that the providers are going to change and go to a usage-based system, mainly because their costs are being driven up so high. And also because, as we are all fond of talking about providers in the technology era, they love to lure you in with cheap and easy to use platforms only to switch them out when they've got you hooked. But the article was talking about a survey that KPMG did that basically suggests that at least on the corporate side, on the CEO side, the heads of a lot of companies are not prepared to deal with that threat. not prepared to handle it when and if it comes, and they don't really understand the sort of the pricing issues and how to effectively use artificial intelligence if that happens. And I think it probably, well, it's already starting to happen. It's already talk about, how many tokens did you use? And so it didn't directly focus on legal, although I can't imagine that if they did a survey of managing partners, it would be any better in terms of their ability to recognize what could be happening in the marketplace. And we've seen so much hoopla and so many providers, vendors out there just selling the hell out of their product, will do anything and everything. And as long as it's plug and play and you're paying, X amount per month, that's fine and dandy. But if all of a sudden the price goes through the roof, then you're going to have to make some hard and fast decisions about where and when the AI tools should and could be used in order to price them effectively, in order to price your services effectively. And so the point of the article was that that's really not being terribly thought through. And it made me think about the Kirkland and Ellis recent investment. And so I sort of wonder if part of that is driven by their concern about what could happen with the pricing mechanism. Obviously they're going to use the main providers as well as anybody, but if they're able to create their own systems that can do a lot of the work that the providers' systems are now doing, then that drives down the usage that they would have to pay for. Not to mention gives them a little bit more leverage, so that if OpenAI goes to $2 million per token and Anthropic doesn't, then they can easily switch out because they've got their thing. So I just thought it was a very interesting sort of look at what could happen and where we could be headed, particularly as everything on the AI front the cost seems to be escalating, from electricity to data centers to everything else. And so, at some point, I would assume that the providers are going to say, well, we've provided this nice service at a loss for all these times, and so yeah, we've got everybody signed up. So guess what, guys? We're changing our plan.
Yeah,
because we have to make some money. I thought it was pretty interesting.
Yeah, I've long thought that's how this all ends.
So, but
Eventually, they're going to start.
Point, at some point, it could actually be where you would say, because a lot of people, I think, senior lawyers are making that thought. Well, we can reduce our number of associates because everything can be done by AI, and we won't need junior associates because we'll just have them do it. But if the price of that, gets to the point where that's not cost effective, they might be saying, "Oh, we better go out and hire some like humans to do some of this stuff because that'll be cheaper." But of course, those humans won't be able to do anything because their brains have been turned to mush in law school.
Yeah. And I'll just throw in a quick aside to another article I wrote that wasn't on our agenda, but the 8 a.m. Small law report that I wrote up. One of the interesting takeaways, the primary takeaway they highlighted was that collections are still doing okay among small law, which is great news. However, takeaway I took from it was small law was reporting that they were billing more hours per case or per matter, I should say, in the study, which was real data, not vibes. Like, it wasn't like the lawyers being like, "Here's what I'm doing with my time." It was the actual data. And what got me thinking was, it seems as though, I mean, there's no guarantee all those people are on AI or anything, but if AI is out there in the wild, you would think the pressure would be on declining the number of hours per case, per matter. You may be working more hours and have more time during the day to do more things, but per matter, if the hours are going up, that suggests that AI is not delivering the efficiency gains that people think may vibe-like think it is.
Vibe-like. I will say that there seems
or
to
it's generating more or there's generating more cases that can now be handled through AI because it's more cost effective to do that, which is
Well, well,
yeah,
that's the
go ahead.
thing. You would think you could see them billing more time because they have more cases, but
Right.
this was per matter. And I
Per
was like,
matter,
that you
yeah.
would think each matter would be smaller and you'd have bigger, yeah.
Yeah.
Yeah. Maybe they
Rhys,
just think of more questions they ask.
Yeah. There actually seems to be like this conception of like, oh, like I have this like AI tool and all I have to do is like put stuff into it and it will like, do everything I hope it does too. It takes a very long time to test these tools and kind of like to integrate them into workflows too. And the time it takes to actually test and like, completely understand how these tools operate, is hours upon hours. And people are trying to, save costs and get those efficiency gains. And they don't understand the upfront investment of like time to put into, like all these tools. And if they're charging per like, consumption, like it's going to be harder to like have a clear like ROI. Like I've tried to integrate Claude into stuff. It takes a lot of testing. And it's really hard to like, to have stuff exactly right. And I feel like people, are still in like what they call the pilot hell, because like these tools aren't, the tools that people are promising us, like can do everything like, instantaneously. It takes a lot of like fine tuning. And it also like, like takes people trying to like fully understand like, yeah, like how do I change my own workflow too? And it was okay because the tools were cheap. And if you had like a, $2,100 subscription, you know, that's still cheap. But if it's like, per consumption, like I don't see the value proposition. And I believe it's going to probably harm the industry's adoption too.
so it all ends not with a bomb but a bill, or not with a whimper but a bill, something like that. So Rhys, you were away for off the show for a while, but apparently you were busy because you've done a bunch of research on the investment scene in the legal tech world, and you've got a couple of stories related to that. You want to fill us in? I know our time is starting to run short here, but
Yeah, I'll keep it short. So I was able to just gather all the data on all the investments in the space and funding rounds since January. So like January to the end of June. I had that tab open. 1 second, I don't know where it went. Too many tabs. Here it is. And like I was just like I created this cool like infographic chart of all the legal tech funding rounds since January, just to kind of take the pulse of the industry in the first year, like half of 2026. And surprise, surprise, Harvey and Laura are like on the top. Like Laura closed a total of like 600 million, and Harvey was just behind at 200. What I found interesting though was the companies who came after them. They are a ton of companies in the UK, so there seems to be a huge spike in like, funding for UK outfits like Law Hive and Wordsmith, and the real estate platform Orbital. And there also seems to be a spike for like the like hybrid law firm, as they refer to themselves, like the the AI native firms too. And it's kind of a surprise, like I haven't really seen like UK funding take off. It's really taken off in 2026, and it seems to be a ton of interest also, like around hybrid or the ABS firms too. And all these firms are calling themselves the AI native firm, and that's driving us crazy. I like to refer to them as a hybrid firm because they're associated with a tech startup. Like just an aside too, it's insane like what firms will call themselves AI native firm. We were actually talking to a big law firm who's been around for centuries, and they tried to call themselves an AI native firm too, and I'm like, that is insane. So like it's just a cool overview of like all the funding rounds. I was also able to extract all the investors too, from January to the end of August, in the second article. And I also did a cool chart about like, which investors were the most active over these 6 months of 2026, and why Combinator and the Eagle Tech Fund were the two most active, and they invested in 5 funding rounds. I will say one
So that's
surprise.
by numbers of rounds, not by dollars, right?
Yeah, yeah. Like it's just by like the number of
Yeah.
rounds. It was actually hard to compare stuff by dollars because of 2 companies named Harvey and Legor that blew our charts off the chart. I will say that like Rel Labs, which just launched in October, is really active. It's like done 3 rounds to date. And it's pretty cool. So like the most active funders with 3 rounds each was Sequoia, Rel Labs, General, Catalyst, and Andreessen Horowitz. And apologies if I don't pronounce that well. I don't say that out loud often. It's just like stuff I'm just trying to keep track on. It's always interesting to follow the cash, and there's a ton of it in the industry. And it's interesting to see like where it goes. And hybrid and AI native firms seem to be really taking off, and there seems to be a huge explosion overseas as well.
Yeah. And this is before Norm, right? Before Norm's raise last week?
Yeah, that's right. Yeah. And they actually just had a $120 million round too.
Yeah.
That saw funding from like Blackstone and the former chair of, I believe, Kirkland too. So like they're really taking off. So like all these like hybrid firms are just flush with cash, and they are, you know, trying to replace associates with the AI agents, which ties into our past conversations as well. So like we have a kind of like real time view too on like if it's actually going to work out, and how defensible those agents eventually will be. As I assume there's just going to be a few jobs of like the experts and all the AI agents everywhere. So I guess like just get some experience trying to check the agents, because that's going to be a huge skill in the future, I guess.
Yeah. This is really interesting. Great. All right, we got all of 4 minutes. I'm not sure we have time to get to Victor and Niki's stories. I mean, Niki, I don't know if you want to hit it real quick. I mean, we talked before about this issue on the show, maybe while you were on sabbatical. I don't know,
Yeah,
but
I'm
not the
catching
particular
up.
case. It was another more recent case out of New York on this privilege issue when using AI. Um, and it was an interesting case and you had a good write up on it. Um, and
Yeah,
then, yeah,
I'm just playing catch up a little bit with my daily record articles from when I was out. So some of the things I'm writing about are a couple weeks old, and I mean, this is just I'm continuing to track the different cases that are coming down or have come down that relate to work product uh, and work product doctrine and attorney-client privilege, and this is just one of them. And I'll just put a link in there, but I don't think we need to go over it. This one deals with a pro se litigant. So, but I think they're all just, the only thing I would say is they're all just sort of, regardless of the nature of the litigant, with the work product doctrine, they're all kind of fallen into the column I had hoped and thought that they would, which is not treating AI any differently, at least for these purposes, than other types of tech, which is where I think it ought to be going. So we'll see what happens over time. And there's other ones I've written about too, so maybe I'll submit those depending on what I've got going on each week here. So we'll see. But I'll leave the link there.
all right. Well, I think that's going to have to do it, Victor. Sorry we didn't get to your story today, but we will. Who knows? Maybe we'll have a really week next week when nothing happens, and we can go back and talk about that one. The other interesting one I saw in the ABA Journal was the one on the asking the Supreme Court to issue an order banning judges and their clerks from using the prediction betting. What are they called? Prediction
Yeah,
betting
prediction,
applications.
yeah,
Yeah,
yeah.
which is really interesting. I kept watching that during the USA game last week just to see how the numbers were changing on it. Anyway, all right. Well, thanks to everybody. Yeah, Kelsey, Mike, thanks, and the other one. All right. Well, thanks to everybody, and we should be back next week, right? No holidays, no conferences, no nothing. Maybe we'll be back here next week. I hope so, and we'll see what we have to talk about then. So have a good week, everybody.
So long, everybody.
Take care, everyone.
Take it easy.